Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruin decision.
Breaking news from the State House. One of the big bills in front of the Senate, the assault weapons ban.
This is a 6-3 decision written by the senior-most Justice Clarence Thomas.
Here in the U.S., the U.S. Supreme Court is hearing arguments on a $10 billion lawsuit.
It triggers something in me that something has to be done.
It also puts state laws in jeopardy that are similar to this law, which required people to show proper cause when they apply for permits.
Two regular people walked into a government office, filled out some forms, and accidentally triggered the biggest shift in American gun rights in over a century. What happened next sent shockwaves through every courthouse, police department, and state capitol from coast to coast. And if you own a firearm or ever plan to, what I'm about to break down will completely change how you understand your rights. Robert Nash and Brandon Koch weren't activists. They weren't looking to make history. These two New York residents did exactly what the system told them to do. They completed their background checks, sat through safety courses, maintained clean records. When they applied for permits to carry concealed firearms, they assumed following the rules meant getting approval. They were wrong. The state denied them both. And the reason was something most Americans had never heard of. They lacked proper cause. Translation? They couldn't prove they needed protection more than anyone else walking down the street. For over 100 years, this vague standard had given officials the power to decide whose safety mattered and whose didn't. Nash and Koch refused to accept that answer, and their refusal set off a legal earthquake that's still causing aftershocks right now. When their challenge finally reached the Supreme Court, the justices didn't just rule in their favor. They issued a 6-3 decision that fundamentally rewrote how gun laws work in America. Justice Clarence Thomas delivered an opinion that legal experts are calling a constitutional reset. The core message was simple but devastating to decades of regulation. The Second Amendment isn't something the government gets to negotiate. For years, courts had been weighing public safety concerns against individual rights, essentially allowing states to restrict firearms whenever officials felt the risk was too high. Thomas ended that practice with a single standard: any gun law must be justified through the Constitution's original text, the historical record, and established tradition from America's founding era. Modern crime statistics don't matter, public opinion polls don't matter, political preferences don't matter. If a restriction can't find a historical twin from the late 1700s or early 1800s, it's now constitutionally vulnerable. Here's where things get wild. This wasn't just about one state or one type of permit. The Supreme Court created an entirely new framework that every court in the country must now follow. They call it the text, history, and tradition test, and it's already tearing through gun regulations like a wrecking ball. Under this standard, prosecutors and state attorneys can no longer defend a law by arguing it keeps people safe or reduces crime. They have to dig through historical archives and prove that similar restrictions actually existed when the founders wrote the Second Amendment.
It conflicts with the Second Amendment's right to bear arms.
The right to keep and bear arms shall not be infringed.
For the Supreme Court, it's all about language, reasonable suspicion, objective reasonable belief, or probable cause.
We won't see changes overnight, but it's going to be quick.
This is a case that's been bounced around back and forth throughout the court system.
Saying setting a higher threshold in an emergency could mean life or death.
It's a case that legal experts will be watching closely.
Think about the implications. If California wants to limit magazine capacity, they need to show that Americans in 1791 faced similar limits. If Illinois wants to ban certain rifle features, they need historical precedent from the founding generation. If Maryland wants mandatory waiting periods, they need evidence that colonial citizens dealt with the same requirements. No historical proof, the law collapses. Judges in multiple states are already using this test, and entire sections of state legal codes are failing to meet it. What used to be decided through legislative votes and agency regulations now lives or dies based on what happened 2.5 centuries ago. But here's what nobody expected: the sheer scale of the response. Within months of the ruling, permit offices across America were absolutely flooded. States that had built entire systems around denying applications suddenly had no legal ground to stand on. Hawaii went from having just 187 active civilian carry permits to processing over 3,800 applications in 8 months. In Honolulu County specifically, approval rates jumped from nearly 0 to above 80%. Los Angeles County, which used to issue around 400 permits annually, got buried under 8,000 applications in 6 months. New Jersey saw its yearly total explode from roughly 1,200 permits to more than 45,000 in the first year alone. The bureaucratic infrastructure designed to restrict access couldn't handle actual demand. Offices worked overtime, states hired emergency staff, and the system that was built to say no was suddenly forced to say yes thousands of times over. Now, you might think that's where the story ends. Rights restored, citizens empowered, game over. But some state governments weren't about to let a Supreme Court ruling get in their way. What happened next is what legal analysts are now calling malicious compliance. These states technically followed the court's order, but they found creative ways to make those rights virtually useless in practice. California led the charge with Senate Bill 2, which transformed most public spaces into what the law calls sensitive places, where carrying is prohibited. The list is staggering. Government buildings, public transit, parks, any restaurant that serves alcohol, entertainment venues, banks, hospitals, libraries, and even entire downtown commercial districts. Researchers who mapped out San Francisco's restricted zones discovered something remarkable. A person with a legal carry permit can't walk more than 3 city blocks in most areas without crossing into a prohibited zone. The permit exists on paper, but using it legally becomes a logistical nightmare. New York adopted a similar strategy. The state passed emergency legislation requiring permit applicants to hand over 3 years of social media history for character review. They also created more than 20 categories of sensitive locations, including private property, unless the owner specifically posts a sign allowing firearms. Most private businesses don't post these signs, which effectively bans carry in the vast majority of indoor spaces. The message from these coastal states was crystal clear. If the Supreme Court won't let us block permits, we'll make actually using them so complicated and risky that most people won't bother. But the ripple effects go deeper than most people realize. Behind every carry permit is an entire industry. We're talking about mandatory training centers, fingerprinting services, licensing offices, and instructors who've built careers on government requirements. Together, this ecosystem generates an estimated $1.3 billion annually nationwide. In California alone, the 16-hour training requirement costs between $200 and $400 per applicant. With over 100,000 new applications after the ruling, that translated to roughly $40 million in course fees within a single year. Maryland collects close to $18 million annually through similar programs. But now federal courts are starting to question whether these high costs create an unconstitutional barrier that prices out low-income citizens from exercising a fundamental right. If those challenges succeed, mandatory training laws could disappear entirely, and the billion-dollar industry built on them would collapse overnight. And the legal battles are only accelerating. After the Supreme Court's ruling, the number of Second Amendment lawsuits exploded. As of late 2024, over 300 active cases are working their way through federal courts, all using this new constitutional test to attack gun restrictions that have been on the books for decades.
And today, the Supreme Court said that's unconstitutional. That puts a limit on the right to have a gun.
You couldn't get a firearm and carry it just because you wanted to be protected against criminals.
There is a difference between states deciding how they want to regulate any number of things versus stripping people of their rights to self-defense.
This case could reshape how far states can restrict your right to carry.
Give us transparency in how you're going to handle them. And if there's a roadmap of what you're going to follow that's more clear, then it's going to be a fair process for everyone.
18 separate cases across 7 states are targeting age restrictions that prevent 18 to 20-year-olds from buying handguns, arguing that young adults served in founding-era militias with their own weapons. Federal judges in Minnesota and Oregon are reconsidering lifetime bans on nonviolent felons, questioning why a decades-old fraud conviction should permanently erase constitutional rights. Other cases are challenging assault weapon bans, 10-day waiting periods, and subjective moral character requirements that have no historical precedent whatsoever. Legal experts estimate there's more than $80 million in active Second Amendment litigation happening right now, and many of these cases are headed back to the Supreme Court by 2026. When that happens, the justices will be forced to clarify just how far this text, history, and tradition standard actually extends. That next round won't just decide gun policy. It will define the constitutional limits of government power for an entire generation. So what does all this mean for everyday gun owners? This isn't some abstract legal theory that only matters to lawyers and politicians. This ruling changes how you carry, how you store, and even how you travel with a firearm. States that once made permits nearly impossible to obtain now have to approve applicants who meet basic requirements. Those endless delays, arbitrary denials, and mountains of extra paperwork that used to be standard practice are increasingly being struck down. If you live in a restrictive state, you may finally have a legitimate path to legal carry, but you're also walking into a maze of new sensitive zone restrictions and constantly shifting local ordinances. That means understanding your local map, studying your state laws, and knowing your rights before you step outside with a firearm becomes absolutely critical. Even rules around storage and transport are being reevaluated under this new constitutional framework. The legal landscape has fundamentally changed, and it's still moving. Every responsible gun owner now carries more than just a firearm. They carry the responsibility to stay informed in real time about what's actually legal where they live. Because even after the Supreme Court's landmark ruling, anti-gun politicians didn't give up. They just switched tactics. Instead of outright bans, they're flooding the system with red tape, new training requirements, hidden fees, endless background check procedures, and location restrictions disguised as public safety measures. On paper, it looks like they're following the law. In practice, it's systematic obstruction. Some states are drafting model legislation specifically designed to exploit every loophole the Supreme Court left open. It's a slow, quiet form of resistance meant to exhaust gun owners through confusion and cost. The courtroom battle may have paused, but the bureaucratic war is just getting started. That's why staying informed isn't optional anymore. It's survival. Every new bill, every agency regulation, every local ordinance needs to be watched because rights don't disappear overnight. They erode gradually through paperwork, one bureaucratic signature at a time. The people who pay attention are the ones who keep their rights intact. What the Supreme Court handed down isn't just a legal decision. It's a complete transformation of how gun rights work in America. The next permit application, the next legal challenge, the next courtroom fight will all be decided under these new rules. Understanding how the law actually works before you need it isn't paranoia, it's protection. The game has changed, and knowing the new rules could be the difference between exercising your rights and losing them to technicalities you never saw coming. That's it for today, folks. See you in the next video.